Hi, I'm Daniel Strickland. I'm an associate at Eversheds Sutherland in the Washington, D.C. office. I'm joined by Susan Seabrook, who's a partner in this office. We're here to talk to you today about leveraging tools of tax controversy to narrow the known unknowns. As you're well aware, the Tax Cuts and Jobs Act provided a lot of relief, but it also provided a lot of uncertainty. We've put together a group of tools and processes that you can take advantage of to achieve certainty.
We've got 4 phases of tools. Daniel, can you address the first phase of tools?
Absolutely. Phase 1 tools are really not contingent on where you are in the exam process. You can always ask for a private letter ruling, where you go to the IRS and ask them to assume your facts and give you the answer. You can ask for a pre-filing agreement, where the IRS comes in and audits your specific facts before giving you an answer. If you're dealing with transfer pricing, you can ask the IRS for an advanced pricing agreement, where you go in and agree to a particular methodology. And lastly, you can voluntarily go in to sign a closing agreement. Tell the IRS you made a mistake and you'd like to fix it. You want closure.
Next, there's phase 2 tools, and those are very specific to cases that are within exam jurisdiction. So unlike the tools that are really not contingent on this, these tools relate specifically to exam. And the first is Pub 5125, and that describes the process. So you should think about consulting that so that you understand how the process unfolds so that you can actually be prepared for each stage. There are a number of other tools to be aware of. The IDR process can be used as a proactive tool as opposed to just a defending tool, in the sense that you can discuss the IDRs, the content, the response date, and so forth in advance under that particular industry directive initiative. Also, there are delegation orders available to you to either apply former appeals settlements or to apply appeals settlement guidelines if there are any for your issue. If you and the exam unit agree on the facts, you can also seek a TAM, which is a technical advice memorandum, to send your agreed facts up to the national office and have their help in opining on what the resolution should be. Finally, there's early referral to appeals, and that allows you to peel off an issue and send it up to appeals for resolution if you agree on the facts, but you're simply not going to be able to resolve it, and then you can continue with the rest of the exam while that's being handled by appeals. Fast track settlement is a mediation process that's available, and that involves the taxpayer and exam working with a trained appeals officer as a mediator to resolve the issue at that phase. And finally, again, a closing agreement to achieve finality.
If none of that works, you can always take advantage of these appeals tools. Historically, the appeals process involved exam presenting its view of the issue, letting the taxpayer present only to appeals, and then negotiate with appeals to reach some sort of middle ground. Today, exam has the ability to be invited to be in the room while the taxpayer presents, but still has to leave when the taxpayer is negotiating with appeals. However, the rapid appeals process allows exam to stay involved throughout the entirety. This may not be right for every taxpayer, but it can be a useful tool. We also have the ability, if that doesn't work, to go to post-appeals mediation, but keep in mind this is a non-binding process. If you're not able to reach resolution, there's always litigation.
Right, there's always litigation, and one tool you can use in litigation is the qualified offer. And the qualified offer is where the taxpayer submits a written settlement offer to the IRS. And if the IRS declines that offer and then the taxpayer is successful in litigation and the liability is either equal to or less than what the taxpayer was offering to pay, the taxpayer is the prevailing party for purposes of claiming litigation fees and costs in the litigation. So that can be a very effective tool. The other thing to remember is that generally, if a taxpayer has not yet been to appeals, post-docket appeals is available. So once the case is docketed, most cases, not all, have the ability to go back to appeals jurisdiction and take advantage of some of those tools you mentioned previously. And finally, you can always settle a case at any stage prior to litigation or in the midst of litigation. So that's something to always remember. There's always an opportunity to reach out, sit down, and resolve the case.
Susan and I have put together a helpful chart containing these procedural tools, as well as a few others. In the chart, we've got short descriptions and cites to authority that supports those processes. It'll give you a head start.
So if you have questions you need to achieve certainty and you're looking for some tools, please consult our website at eversheds-sutherland.com, and you will find our downloadable chart as well as other bottom line videos. Thank you very much.